Hello everyone, my name is Ananya Rajput, a law intern at LEXIS and Company. So today in this video, we are going to discuss nature of Indian Constitution. Now the Constitution of India is not an end but a means to an end. Not mere democracy as a political project but a socio-judicial process which opens up through a humanist, radical social order the opportunity to unfold the full personhood of every citizen. The Indian federalism is unique in nature and is tailored according to the specific needs of the country. Federalism is a basic feature of the Constitution of India in which the Union of India is permanent and indestructible. Both the center and the state are cooperating and coordinating institutions having independence and ought to exercise their respective powers with mutual adjustment, respect, understanding and accumulation. Tension and conflict of the interest of the center and the respective unit is an integral part of federalism. Prevention as well as amelioration of conflicts is necessary. Thus, the Indian federalism was devised with a strong center. Federalism with a strong center was inevitable as the framers of the Indian Constitution were aware that there were economic disparities as several areas of India were economically as well as industrially far behind in comparison to others. The nation was committed to a socio-economic revolution not only to secure the basic needs of the common man and economic unity of the country but also to bring about a fundamental change in the structure of Indian society in accordance with the egalitarian principle. With these considerations in mind, the constitution makers devised the Indian Federation with a strong union. Federalism constitutes a complex governmental mechanism for the governance of a country. It seeks to draw a balance between the forces working in favor of concentration of powers in the center and those urging a dispersal of it in a number of units. A federal constitution envisaged the demarcation of the governmental function and powers between the center and the regions by the sanction of the constitution, which is a written document. From this, it follows two necessary consequences. First, that the invasion by one level of government on the area assigned to the other level of the government is a breach of the constitution, and second, that any breach of the constitution is a justifiable issue to be determined by the courts as each level of government function within the area assigned to it by the constitution. Being aware that notwithstanding a common culture heritage, without political unit, the country would disintegrate under the pressure of various forces, the Constituent Assembly addresses itself to an immensely complex task of devising a union with a strong center. In devising the pattern of the center-state relations, they were influenced by the Constitution of Canada and Australia, which have a parliamentary form of government, and America, which has a presidential form of government. The Government of India Act 1935 was also relied upon with significant changes. The Constitution cannot be called federal or unitary in the ideal sense of the term. It is stipulated in the Constitution that India will be a union of states, that is Article 1. The Constitution thus postulates India as the union of states and consequently the existence of federal structure of governance for this union of states becomes a basic structure of the Union of India. Dr. B.R. Ambedkar, the principal architect of the Constitution, observed the use of the word union is deliberate. The drafting committee wanted to make it clear that through India was to be a federation. The federation was not a result of an agreement by the states to join in the federation, and that the federation not being the result of an agreement, no state has the right to secede from it. Through the country and the people may be divided into different states for convenience of administration, the whole country is one integral whole. Its people and a single people living under a single imperial derived from a single source. The Constitution makes a distribution of powers between the Union and the states, the jurisdiction of each being demarcated by the Union, state and the concurrent list. In case of a conflict between the two legislatures over a matter in the concurrent list, the will of the Parliament prevails. The supremacy of the Constitution, the hallmark of the Federation, is an important feature of the Indian polity. Neither the central government nor the state government can override the contravene the provision of the Constitution. Another prerequisite of a federation, namely an independent judiciary, an interpreter and a guardian of the constitution, is also present in the Indian Federation. The issue of federalism was carried forward in the case of S.R. Bomai versus Union of India. 4 opinions were rendered expressing varying views. Justice Ahmadi opined that in order to understand the true nature of the Indian Constitution, it is essential to comprehend the concept of federalism, the essence of the federation in the existence of the union and the states and the distribution of power between them. The significant absence of expression like federal and federation in the constitution, the powers of the parliament under Article 2 and 3, the extraordinary powers conferred to meet emergency situation, residuary powers, powers to issue directions to the state, concept of single citizenship and the system of integrated judiciary, which created doubts about the federal nature of the Indian Constitution. Thus, it would be more appropriate to describe the Constitution of India as quasi-federal or unitary rather than a federal constitution in the true nature of the term. In the opinion of Justice Ramaswamy, the union of the federation has no roots in the past, and hence the constitution does not provide mechanism to uphold the territorial integrity of the state above the power of the parliament. We can henceforth see that the Indian judiciary has interpreted in the constitution to declare India a unitary nation. The view of the apex court has lately undergone a change. The court has recognized the fact that the framers of the Indian Constitution intended to provide a federal structure with a strong center which would prevent the nation from disintegration. In the basic structure thesis case, Keshwanand Bharti versus the state of Kerala, some of the judges were in the full constitution bench expressed federalism as one of the basic features of Indian Constitution. In another case, Justice Bhagwati described Indian Constitution as a federal or quasi-federal. In Satpal versus State of Punjab, the Supreme Court again held that ours is a constitution where there is a combination of federal structure with unitary feature. In Gangaram Moolchandi versus State of Rajasthan, the Supreme Court reiterated the Indian Constitution is basically federal in form and is marked by the traditional characteristics of federal system, namely supremacy of constitution, division of power between the union and the state, and existence independently judiciary.